He basically is not.
Jefferson County Court at law number 2 is in session. The court is in session in cause number M327280. Case is styled the state of Texas versus Albert Martinez. Let the record reflect that Mr. Martinez is present in court with his attorney, Attorney John Macy. Let the record also reflect that the state is present with Assistant District Attorney Andrew Hubel. State, are you ready?
State's ready, Your Honor.
Defense, are you ready?
Ready, Your Honor.
Okay. At this time, the court is going to read the motion to revoke the probation. And it states that now comes the state of Texas by through a Raymond Shearer, Assistant Criminal District Attorney for Jefferson County, and respectfully show unto the court of the following: that Albert Martinez, defendant in above styled and numbered case, was tried on the 15th day of November of 2021 for the offense of DWI enhanced with a blood alcohol concentration level of 0.15 or more, a misdemeanor, and that on such date, the defendant was found guilty and assessed punishment at a term of 60 days confinement in Jefferson County Jail and a fine of $700. In accordance with the provisions of Article 42.12 of the Code of Criminal Procedure of the state of Texas, said confinement was probated for a period of 1 year upon the conditions that: Condition 4, report to probation officer as directed by the court or probation officer and obey all rules and regulations of the probation department. Condition number 8, pay a fine of $700, restitution of $0, pay court costs of $1,122, pay probation fee of $60 each month, pay court-appointed attorney's fees of $250 in monthly installments of $200. Condition number 18, perform 40 hours of community service at a rate of 5 hours per week until completed or otherwise specified. And condition 19, pay for, attend as directed, and successfully complete DWI education program as directed by the court or probation officer. That said defendant, after receiving said probation, violated the terms and condition thereof, in the following manner, to wit: number one, the said Albert Martinez failed to report to the Jefferson County Probation Office as ordered by the court the months of May, July, September, and October of 2022 as directed, in violation of condition 4 of the defendant's probation order. Number two, the said Albert Martinez failed to pay court-assessed fees as ordered by the court, and as of October 25th of 2022 was $1,849 in arrears, in violation of condition 8 of the defendant's probation order. Three, the said Albert Martinez failed to perform the community service hours required as ordered by the court, in violation of condition 18 of the defendant's probation order. And number four, the said Albert Martinez has failed to attend Texas DWI education program as ordered by the court, in violation of condition 19 of the defendant's probation order. Premises considered, therefore, the Assistant Criminal District Attorney, Jefferson County, moves that the court to cause a warrant to be issued for the arrest of defendant, and upon defendant's arrest, a hearing held and probation revoked in this cause, as the evidence and judgment of the court adhere to all, and is signed by the Assistant Criminal District Attorney. Now, Mr. Martinez, to allegation number one that state that the said Albert Martinez failed to report to the Jefferson County Probation Office as ordered by the court the months of May, July, September, and October of 2022 as directed, in violation of condition 4 of your probation order. How do you plead, true or not true?
Your Honor, before, I'm not sure this is the appropriate time to do the motion to revoke. My understanding, the reason we're here is because I made a motion, if you want to call that an open court, which caused this to be set for a contested hearing today.
Right.
And I'd ask the court to take, judicial notice of the fact that that file, well, first off, that motion to revoke, which says that he violated, which it was filed on October the 31st of 2022.
Yes.
Now, on October 31st, 2022, it's they wrote that he was in violation of 4212 of the Texas Code of Criminal Procedure. 4212 of the Texas Code of Criminal Procedure was repealed in 2017, or I think the new statute became effective in September of 2019, if not September. Actually, it became a 42A section took the place of 4212 in 2017. So I would argue, number one, that that this is a wrongful quoting of a statute that had been repealed. But that aside, I'd like you to take judicial notice of the fact that on November the 1st of 2022, you signed an order issuing, ordering a habeas be issued for Mr. Martinez because of the motion to revoke that had been filed the day before. The habeas issued on, and I have a copy of it if you want to see it.
Okay, it should be in the court's file.
It should be in the
I'm getting
court's
to the
file. It
file
was
right now.
issued on, according to the, handwritten by the sheriff's
Okay,
office. The sheriff received the capias on November the first, 2022 at 4:32 PM, which was the same day you
November.
ordered the capias to be done. And then, according to the sheriff's return, Mr. Martinez, the capias was executed on March the 15th of 2024.
okay, hold on a minute.
499.
Okay, let me find the KPS. Hold on a minute.
I'm sorry, what?
I was asking what date are you ordering 4212 was revealed?
What date, what?
Are you ordering the 4212 was revealed?
4212 was replaced by 42A. I believe it was in 2017. But
Okay,
since they don't show my PCDLA site doesn't even show 4212 anymore. Because it was repealed and replaced by 42A. And so specifically, the thing I'm complaining about, Judge, is 42A .756, which is the due diligence.
okay, hold on a minute. I see the motion to revoke that was signed. The motion that was signed on November 1st of 2022. Hold on. And you said, I don't see the KPS. I see what it was. I see a notation saying a warrant was received on, it's just a notation in the file. I don't have the actual, return. I don't even have the warrant, but I see here it says return warrant received November 1st of 2022.
I printed this off of my portal earlier today.
What date did you, what date was that filed? Is that file stamp on there?
This.
Okay, let me see. That should be, was that the one on,
File stamp.
is that 3/18/24?
Yes, Judge.
Okay, hold on a minute. I got,
Which would have, I presume, be when they returned it. Or they.
warrant return, okay, okay.
And it reflects that he was actually arrested 4 days earlier on.
Okay,
3/14/22.
I see here on the KPS, it has sheriff's return came to the hand on the first day of November 2022 at 4:32 PM and executed on the 15th day of March of 2024. Is that correct?
Yes, Judge.
Okay,
Although there's a notation underneath that.
it said
that
arrested
says arrested 3/14, so. I don't know.
3/14 of 2024. Okay,
So.
now what was your, you had,
So under 42, the correct statute, I believe, is 42, my defense is 42A .756, which is the due
okay,
diligence.
okay,
Statute.
hold on a minute. It says 42
42A .756.
.756.
It's almost the last statute in 42A. That deals.
You said 756?
756, yes, Judge. Which is
Okay.
the
Due diligence, okay?
revocation.
It is an.
I think revocation might start in 751 or somewhere, I'm not sure.
Now, just for the record, now that statute reads as for Article 42A.756 due diligence defense. Say for purposes of a hearing under Article 42A.751D, it is an affirmative defense to revocation for an alleged violation based on a failure to report to a supervision officer as directed or to remain within a specified place that no supervision officer, peace officer, or other officer with the power of arrest under a warrant issued by the judge for the alleged violation contacted or attempted to contact the defendant in person at the defendant's last known address or last known employment address as reflected in the files of the department serving the county in which the order of community supervision was entered. Now, I mean, if we look at that, it talks about a failure to report and a failure to, upon the probation department to contact him. That's a defense.
Yes.
Okay, but it also states that obviously the probation officer or whoever can testify as to their records. That has not been done yet. Okay, so when you say it wasn't time for that, I just need to know whether or not he's pleading true or not true to these allegations. Then we can conduct the hearing. Once we conduct the hearing, the state can bring forth whatever evidence it has, and then you could lodge your defense.
That's fine, too.
Okay, so let's get back to the motion. So to the motion to revoke probation. Now to the motion to revoke probation. To allegation, number one, how do you plead, true or not true?
True or not true? You have intelligence.
Okay, now allegation number two, it says the defendant failed to pay court assessed fees as ordered by the court. As of October 25th, 2022, you were 1,849 in arrears in violation of condition 8. Is that true or not true? Allegation number three alleges that you, Albert Martinez, failed to perform community service hours as required, ordered by the court in violation of condition 18. Is that true or not true? And allegation number four alleges that you, Albert Martinez, has failed to attend DWI education program as ordered by the court in violation of condition 19 of the probation law. Is that true or not true? Okay. Now, are you pleading true to these allegations freely and voluntarily?
Yes, sir.
And are you pleading true because they are true?
Yes, sir.
Okay, now, Mr. Macy, your client is pleading true to these allegations. So he's admitting to the allegations. I do understand your concern about the reporting and the affirmative defense that you would like to raise. I mean, the court.
Your Honor,
Yes.
given the fact that the defendant has pled true to all four counts, the state's willing to abandon count number one.
Okay, so the state is abandoning allegation number one. Okay, so that leaves, so we have three allegations that the defendant has pled true to. Now, and the court is also going to take judicial notice of the court's file. Okay. And so at this point, the court can if you would like to put on any type of punishment evidence, I don't know if y'all have an agreement. I don't think y'all have an agreement. Is that correct?
There is no agreed plea at this point, Your Honor. State has no evidence to put forth in regards to punishment.
Defense?
I would like to call Mr. Martinez.
Okay, Mr. Martinez, you can come forward. You're gonna take the witness stand. Stand before the bench and raise your right hand, and I'll swear you in. Yeah, just stand right there. I'll swear you in. The other hand, sir.
Oh.
Mr. Martinez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Martinez, you may put your hand down. Now, Mr. Martinez, when she finished hooking up the mic, you can take a seat in that chair. I think that's good. Ms. Mosby. Turn that camera just a little bit more, what you can see him on the witness stand.
This one?
That one, right, to where you can see him on the witness stand. Right,
That's good.
good. Mr. Well, let me do this here before we go any further with the punishment, because obviously he has already pled true to, the court is going to find that the defendant has pled true to allegations 2, 3, and 4. The court is going to find that his plea was freely and voluntarily given. The court is going to find that there is sufficient evidence to revoke his probation, and his probation is hereby revoked. Now, at this point, the court is going to have some punishment evidence that's presented by the defense. Mr. Macy, would you like to go forward?
Yes, Your Honor, thank you.
Okay.
Mr. Martinez, state your name for the record.
Albert Martinez.
Mr. Martinez, one of the things that you pled true to was allegation number 2, that you were in arrears $1,849 on October the 22nd, 2022. Could you afford to pay that money on October the 25th of 2022?
No, sir.
Did you have a job?
I had a job.
What were you doing?
I work at a warehouse there at South 23rd. It's called ITI.
How much money did you make?
Well, like I get paid by every 2 weeks. It's like 1,000, 1,200 a month.
Okay. Do you have any dependents?
Yes, sir. I got 2.
2 kids? Do you support them?
Yes, I was paying child support at the time.
Do you know how much money you had to pay in child support?
If I'm not mistaken, for both of them, I was paying like 1,500, 1,600 around there, I think, for both of them.
Per month?
Yes, sir.
Okay. What did that entail? I mean, was that court ordered or?
Yes, by the court, yes, but we had it through, it was the time of the COVID, but we had it through Zoom. The court meeting for child support.
Okay, and what about, so in addition to supporting your children, did you support anybody else?
No,
So you
myself,
supported yourself?
yeah, myself.
Okay, so how much did it cost for your rent?
I was paying 800,
Okay. And what about your monthly food expenses?
but like 150, 200.
So, did you ever pay any, of the court ordered, fees that you were ordered?
That I know of that I can remember, I don't think so.
Now, you also pled true to, failing to perform your community service hours. How many hours were you supposed to,
I can't remember how many hours, I can't remember.
you don't know? Did you ever try to, do any community service?
I tried, but I never made it because I walk everywhere, like to work, or if I need to, go to the store for my kids or stuff like that, I walk. I didn't have no ride, no one gave me rides or nothing.
And then when you were arrested, you, you were found guilty on November the 15th of 2021 for DWI with a high blood alcohol content. When were you arrested for that officer? Do you remember?
No, I don't remember nothing about that day. I don't remember nothing.
Okay. If I told you that the information in that case says that you were arrested, or you committed the offense on or about July the 10th of 2020, would you have any reason to dispute that?
No, but I don't remember, like, I don't remember.
So then you got arrested for DWI. They took your driver's license away, right?
I didn't have no driver's license, sir.
Oh, you didn't even have a driver's license. So you didn't have a driver's license, you didn't have a car. Which is why you have trouble getting around and complying with the thing. So tell me now, these, in your current situation, who do you live with?
Right now, I'm staying with my sister.
Okay. How old are your children?
My son's 8, my daughter's 4.
Do you still support them?
Yes, sir.
Okay.
Right now, I take more care of them since their mom's out there on drugs and don't want nothing to do with them.
So they actually live with you?
No, they're staying at my ex-brother-in-law's house, my baby mama's brother. But every time I go see them, whatever they need, I go get for them and stuff like that, and I get them on the weekends. How child support told me, like, I get them every weekend and stuff.
So, even though you were already sentenced to 60 days in jail, sentenced to 60 days in jail, are you asking the court to give you a sentence of less than that now?
Well, if they can, like, or weekends or something, because right now, well, I'm fighting another case. We're not here, right, in a different county. And that one, what I do, once I go to that one, that's when they're gonna give me time. You know what I mean?
You have a pending charge somewhere else?
Yeah, in Hidalgo County.
In the Hidalgo
Yeah.
County. Do you know what level of a, offense that is?
It's a felony.
It's a felony?
Yes, sir. It's 2 counts, but they're put together.
Okay. So in addition to this, you have to, I take it, report in Hidalgo County.
Right now, they got me on the monitor on GPS, so you know where I'm at.
Okay, so you're wearing a monitor right now.
At the moment, yes, sir. Like, I know once they lock me up for like 4 years, they're gonna revoke my bond from over there.
Okay. Um, I'll pass it with this judge.
Mr. Huber?
So, Mr. Martinez, you have already testified to the fact that you could not afford to make the payments to probation, in this case, correct?
At the time, I couldn't, yes, sir.
But you still could have completed your community service hours.
But it was hard for me, like, get around walking everywhere, like,
And you,
and I know that ain't an excuse,
and
But-
choose a yes or no question.
yes.
Now, you said that you tried to, but were you aware of an opportunity made to you to where you could work 4 hours, and complete the entire, and get credit for the entire 40 hours? Were you given that opportunity?
That I remember, no, because if it was like that, I would probably tried harder to do it, because 4 hours ain't really nothing compared to 4.
Now, you also pled true to failure to attend and complete the Texas DWI education program. Do you recognize why that class is so important, especially to individuals who have been found guilty of DWI? And yet you chose to forgo that class.
Yes, sir.
Do you have any reason why you did so?
It's the same, I couldn't, like, I couldn't go walking. Every time I get off work, I had to walk like an hour and a half, 2 hours home. By the time I got home, I was tired and go to sleep. Wake up early in the morning, do the same thing, walk back to work.
And state has no further questions at this time. State has, state has one rebuttal winners.
Okay,
I'm gonna-
well, Mr., is it all right if I ask Mr. Martinez something? Now, Mr. Martinez, you stated that you worked, but you had to walk to work. And then when you got off work, you had to walk back home. How long was the walk?
Like an hour and a half, 2 walking, like just to get to work, and then an hour and a half every time I got out, like 2 hours back, like 4 hours a day. Like 2 and then 2 back. Sometimes more, because sometimes I get tired from work and stop at the store or something, get rest and then get going.
Now, you stated, where did you work?
I work at South 23rd. It's a warehouse called ITI next to Collins Warehouse. It's one big building, but it's divided in 3.
Oh,
Where Penske's at in the corner.
at the corner of 23rd and College?
Yes, sir. There's Penske's and then the new thing that opened Temco, and then our warehouse ITI is in the middle and then Collins is in the corner.
And where did you live?
At the time I was still staying at Downs Road.
In Carroll Park?
Like, but yeah, more for the park, more over there. And then later on, I gotta know my boss, like, with me and my boss made a good bond. And that's when he rented me out the apartment so I can be closer to work. It was still a long walk though, but it was closer to the work. And at the time, I had no help from no one or nothing. I was talking to my sister and nothing.
Now, you stated that you was working. How much did you get, how often did you get paid?
Every 2 weeks,
And how much did you take home?
like from 1,000 to 1,200 most every 2 weeks.
Okay. You required to pay rent?
Yes, sir.
How much was your rent?
Like when I was staying at Downs, I was paying like 6 plus the bills, so in total it was like 8, 9.
A month?
Yes, sir.
You have to pay utilities?
Yes, sir. Like the bills were like probably like 100 or 200 bucks or 250 sometimes.
And how much, did you, now you said you paid your child support was anywhere from 1,500 to 1,600
Yes,
a
sir.
month?
Yes, sir.
Okay, what about food expenses?
food, like if it was only for me, well, I wouldn't need much, like 100, but when I have my kids and stuff, like 250, I get more food for them than for me.
Now, had you ever had to pay for transportation? And how often would you pay for transportation?
Not, like, not much, like, not a long time, cause sometimes they tell me they go for me or something and they wouldn't, so I wouldn't really depend on the ride, I'll just walk.
And but just for the record, you are the same um, Albert Martinez that was placed on probation. In this case, cause number 327-280 on November 15, 2021. Is that correct?
Yes, sir.
Anybody else have any other questions? Okay. Mr. Mason? Okay, Mr. Martinez, you may step down. All right, Mr. Who I think you would like to call the witness?
I've decided to forgo that at this point, Your Honor.
Okay, let's do this here. Court will take this under advisement at this time. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number M327280, case of Tyler, State of Texas versus Albert Martinez. Mr. Martinez is present with his attorney John Macy. Now, Mr. Martinez, you was previously sworn in, is that correct?
Yes, sir.
Okay, now, Mr. Martinez, I have before me a document that is titled motion to revoke probation. This is the motion to revoke probation that I read up to you earlier. Is that correct? And in this motion, there are 4 allegations. The state is had abandoned allegation number 1. Is that correct, state?
That's right, Your Honor.
And Mr. Martinez, the court read to you allegations 2, 3, and 4, and you pled true to those allegations. Is that correct?
Yes, sir.
And you pled true because they are true? And you pled true not only because they are true, but you also understood everything in these motions, and everything that's in these motions are true and correct in these allegations are true, correct to the best of your understanding.
Yes, sir.
Now, Mr. Martinez, also have before me a document that is titled Misdemeanor Plea Admonishments. You recognize this document? On page 2 of the same document, there's a set of initials, AM on the line next to a box that's checked, NTRP, which means most of the revoked probation, true to allegations 2, 3, and 4. You place your initials on this document.
Yes, sir.
And on page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature? And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document? And on this document, at the bottom, there's a signature. Is this your signature? And at the top of this document, there's one box that's checked. The box that's checked states that you're waiving your right to appeal. Is that correct? Now, Mr. Martinez, before you sign these documents and initial these documents, did your attorney go over these documents with you? And you understood everything that he went over? Is everything in these documents true and correct to the best of your knowledge? Okay. Now, Mr. Martinez, are you a citizen of the United States?
Yes, sir.
The upper states one.
Any objections?
No objection.
No objection. States exhibit number 1 will be admitted. And Mr. Macy, you advising counsel, Mr. Martinez, is there any evidence that he's currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Martinez, your attorney, Mr. Macy, has advised and counseled you. Are you satisfied with his representation? Has he provided fully effective and competent legal representation?
Yes.
Now, Mr. Martinez, the court is going to accept your plea true to allegations 2, 3, and 4. The court will find that you are mentally incompetent to stand trial. The court will also find that your plea and waivers was freely and voluntarily made. And the court will also find that there is sufficient evidence to revoke your probation, and your probation is hereby revoked. State, there is not an agreement. State, do you have an argument?
I do, Your Honor.
Yes. You may proceed.
Thank you, Judge. The defendant has pled true to allegations 2, 3, and 4. The second allegation is in regards to failure to pay fines, fees, and other associated costs. And he's testified to the fact that he couldn't afford that at the time. That's but he could have completed his community service and attended and completed the DWI education program. These are 2 very important parts of probation. He had an entire year to complete 40 hours of community service, which when plotted out over the year is less than 4 hours. But he failed to do so. And also on the stand, he testified to recognizing how important it is that individuals who are convicted or plead to DWI participate in the DWI education program, and that it's important for the safety, not just themselves, but the people of Jefferson County. So given that those facts in mind, I would the state would ask that punishment be assessed at 30 days jail with credit for the 7 he's already served.
He has 7, you said?
Yes, Your Honor.
Okay. Mr. Macy?
Your Honor, Mr. Martinez obviously has some issues with well, they've been in the reporting, but because of his financial situation, he was doing the best he could for what he had. You know, he walks everywhere. He walks, he goes to work, and then he walks back. And he pays so he can pay his child support and support himself and things of that nature. He would have, and he testified in terms of he was having difficulty complying with the DWI education class because he didn't have a way to get there because he had to walk everywhere. But at the same time, I understand the state's concern that you know, the DWI education class is important for someone who's going to be, so they won't drive while intoxicated, but he wasn't driving. He doesn't even have a car. He walks everywhere. So even though the court ordered it, and it's important, I don't know that the state is in any more danger because he didn't attend those classes. He couldn't afford the payments, which is why he was behind on his marriage. And with respect to the community service, it's the same type of thing. It's because he has to walk everywhere. He was having a difficult time doing it. Now, maybe he could have done things differently, and he should have done things differently, but he didn't. We appreciate the state's recommendation. They're not even trying to get him to do the maximum. But if the court is not inclined to allow him back on probation, and then we just ask the court give him something less than what the state recommended, and if the court is inclined not to do that, to allow him to do his jail time on weekends so that he's not, as his testimony reflected, he's wearing an ankle monitor right now. He's not going to go someplace and put, no one's going to be in any danger while he's wearing that ankle monitor. In fact, the court could even sentence him to home. I believe the court has the right or the authority to give him have him do home incarceration. I don't know what if that's the proper term for it, where he'd have to be at his home the entire time, other than possibly you allowing him to continue to work so he can support his children. But we just ask for the court's consideration and leniency in this case.
Okay. Yeah, Mr. Hill, I see your hands up.
Briefly, Your Honor. I don't think that reinstating defendant's probation in this case would be appropriate, considering the fact that he has shown, just based on what he was pled true to on this motion, the ability to comply with those terms, a lack of accountability. And accountability is an important thing, in addition to like the concerns of safety that were reported before. Like, the defendant accepted the terms of this probation in lieu of punishment in the form of incarceration. And he has shown through his inaction in this case that he is unwilling to accept that accountability. So the accountability in this case should be assessed in the form of jail time. And an important point that has been brought to my attention is the fact that in this case, the probation is past expiration, so it cannot be extended.
Yeah, I see where his probation expired on November 14th of 2022, which is almost 2 years ago. So he's not, the court could not extend him on probation if the court wanted to, because that ended November 14th, 2023. That, within a year you could do it, but not afterwards. Okay, now,
And
okay,
sorry.
Mr. Mason.
I was just gonna say, I know that they abandoned my initial issue with respect to the due diligence, but to be candid with the court, since my understanding of when the state chose to codify 42A.756,
Yeah.
that altered my argument. In that, which is why not originally, when that due diligence was part of 4212. My understanding is that the appellate court took the position that any of the probation conditions could technically, I could argue that they didn't exercise due diligence when they codified that.
Right.
My understanding is the court now does not take that position. They only take the position that I'm limited to reporting
Right.
and his not being in the same place,
Mhm.
but the other conditions are no longer, because it was codified. I can't argue that those are, because those were part of the common law.
Right.
And so I'm, to be candid with the court, that's why I'm not arguing further that the due diligence
Right.
should be adhered to, because I think that when he abandoned what he abandoned, that killed my
Right.
initial argument. And I just want to let the court know that that's why I'm not doing it. And I think that that's what the current statute or the current case law would reflect.
Right. Now, Mr. Hugh, what is, do you have any information on Mr. Albert Martinez's criminal history in terms of prior convictions?
A 2012 conviction for resisting in Hidalgo County. There's also a felony drug conviction in the 92nd District Court in Greenberg. Then I see. Twenty 17 assault. And also the doggo.
Okay,
And
you say 2017 what?
assault, Your Honor.
Okay,
Specifically in the assault family.
okay.
And that's what I see.
Okay. And you took that into consideration when you made your recommendations?
Yes, Your Honor. And I did take that into account in making my recommendations in this case, when, the recommendation that I made in this case was the original offer that I made to defense counsel. And given the fact that the maximum in this case is 20, I feel based on the facts of this MTRP, 30 days with credit for 7 is an appropriate offer, from the state. But the ultimate decision, in regards to punishment in this case, we're at the mercy of the court.
Yeah, I know. And Mr. Martinez, you still currently working?
Yes, we're at the same place.
Okay. How many days a week do you work?
I work from Monday to Friday. And it's sometimes it's rare when they tell us that we can work on the weekends, just to catch up on the loads, because sometimes like a lot of trucks come in, and then sometimes they don't. So when they got a lot of trucks come in a day, we go on the weekends to get the loads ready.
Okay.
But that's rare.
This is what I'm gonna do. The court is gonna assess punishment at 40 days confinement, credit for 7, and you're gonna serve them on weekends. Okay,
Yes, sir.
okay, so we're gonna have to draft up the order. Now, your weekend time is going to start this Friday at, what's the date? I mean, is that the 20th?
The 20.
Yeah, that's tomorrow, yeah.
Tomorrow.
Come on, Jim.
The 20th at or before 6 p.m. Well, what time you get off
I
from
get
work?
out work at 5.
Yes,
I'm sorry to interrupt you, Honor, but I think we may have an issue with an ankle monitor. I don't believe the Jefferson County Jail is going to allow him to go in with that monitor. And unfortunately, as soon as that monitor, when they cut it.
oh, he can't cut it out, he can't tamper
No,
with
I'm
it.
saying when they cut it at the sheriff's department, because they will cut that off, then Hidalgo County will issue a warrant. So
Well,
weekends,
Because it's not in our county.
okay,
I'm just saying for the weekend thing, that's,
Well, if it wasn't weekends, they'd cut it off anyway, right?
so,
If he goes to
if
jail.
he goes to jail, they'll cut him out.
But we do have some inmates that are in our jail that still have monitors on them.
right,
I don't know if it's because they forgot to, or they never got around to doing it. But it's possible, because
I guess
they
we have
know he will be
Maybe
there.
add it to the order that it stay on.
I don't know if.
Yeah,
I can't, I mean, that's, the sheriff runs the jail. And that monitor wasn't ordered by this court. She can check. Just have a seat, they don't check. Okay, yeah. Now, the court costs in this, yes. Mr. Martinez, the court cost in this case is $117. Are you able to pay that today?
I can ask my sister, she got some money with her, cause I got paid last week, but I lent the money to her so she can pay her truck.
Okay, so that's your sister that who's
Yeah,
just
that's
in
my
here?
sister right there.
Mr. Gilliam, could you,
Yes, sir.
because you'd have to go pay it. What time they close at? 4:30? You said it's $117? There she is. You come on, how you doing, ma'am? What's your name?
Cristina Martinez.
Christina
Yes.
Martinez. Miss Martinez, would you please raise your right hand? Miss Martinez, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you
Yes,
God?
sir.
You may put your hand down. How are you doing, Miss Martinez?
So far, so good.
That's good. Now, Miss Martinez, I asked your brother, Mr. Albert Martinez, if he was able to pay the court costs of $117. And he said he would have had to ask his sister, which is you, will you be able to pay the $117 today?
Today,
Yes.
I would need to go to an ATM and withdraw it, or if you all have an ATM here, yes.
They have an ATM here, don't they? They still have it?
They used to have one.
They used to have one on the first floor as soon as you come
Yeah.
down the ramp.
I'm not sure if
I
it's
haven't
there.
seen it, but. if
It used to be
somebody
on
can-
it used to be on the first floor.
Or I can,
Oh,
Oh,
but
my
no, but you know what? They don't take cash downstairs, right? Because if you get ATM, you're gonna be getting money out of cash.
yeah.
They don't take cash in the
Oh, they don't take care.
oh, but if you have a credit card, they take credit cards now. Yeah, I think they take,
I'm fairly certain they do take.
yeah, I think they take credit cards.
Okay, I would need to go to my truck, get the card and pay.
Okay.
I can do that.
Okay, so he's ordered to pay, so he'll be able to pay the $117 court cost. Okay, that's what we needed to know. All right, and so again, your weekends, well, you're gonna be given 40 days, credit for 7 days. And you'll be serving your weekends starting tomorrow, September the 20th, 2024 at 6 p.m. And it will continue until the remaining 33 days is served in consecutive weekend, each consecutive weekend. You understand?
Yes.
All right. And this will conclude this hearing. She'll get the judgment, and once she gets the judgment, you'll sign off on the judgment and follow the directions of the bailiff,
No, right.
and then you'll be free to go. I mean, you need to get the paperwork because you need to turn that paperwork in with you when
I
you
need to get
report
with
to the
you.
jail.
Judge, if I can be excused, I need to tell
Yes.
his sister where to go. so
Oh,
that
to the
she
county
can get
clerk's
her
office?
receipt.
Yeah,
Oh, well, she pays at the jail, doesn't she?
no, everything now is in the county clerk's
Oh, is it?
office.
Oh, I didn't
Yeah.
know that.
Yeah.
She brings it in, then I won't start printing because it's gonna show that he owes that.
Okay,
Future reference, there's not an ATM in here anymore.
okay,
There's one there's a. bank.
but she doesn't need one because they don't take cash anyway, so she's gonna get her card. All right, just have a seat, Mr. Martinez. And this will conclude the calling of this hearing and cause number M327280. State of Texas versus Albert Martinez in County Court at Law Number 2 of Jefferson County, Texas. Judge Terrence Holmes presiding. Everyone, please have a blessed day.
Thank you.
Thank you.